All right, it's 5. So, hello and welcome to everyone who is here today. Thank you so much for joining us. So, welcome to Family Law Now After Hours. Today's topic is Ontario divorce court processes. So, while many divorces settle outside of court, some require formal legal proceedings. Understanding the Ontario divorce court process can help reduce stress and uncertainty. This panel will explain each stage, from filing your application to finalizing your divorce order. Please use the question and answer feature to submit your general comments and questions about this topic. For specific questions about the details of your family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be constituted as legal advice. Stay tuned until the end, as we will be sharing how you can schedule a free initial consultation with one of our lawyers. So without further ado, I will introduce our panel speakers. Lisa Clark is a senior law clerk with over 16 years of experience in family law and joined Russell Alexander Collaborative Family Lawyers in June of 2025. Lisa graduated from the law clerk program at Fleming College in 2009 and has developed a well-rounded understanding of the complexities of family law breakdown. She is a member in good standing with the Institute of the Law Clerks of Ontario and recently received her designation as an ILCO's certified expert in family law. Raised in Kawartha Lakes, Lisa is now settled in Peterborough, and she enjoys photography, reading, online gaming, and spending time with her cats. Mark Simpson is an associate lawyer here at Russell Alexander Collaborative Family Lawyers, guiding clients through family law with solutions that save time and resources. He previously ran his own practice, gaining experience in trials, mediations, and arbitrations, and now serves as principal to the firm's articling student. Mark is a father of 3 teenage boys, has coached 2 baseball teams over the past 3 years, and enjoys mentoring. He has also served on the Hamilton Road Business Association Improvement Association Board. Outside of work, he serves on the Middlesex Law Association and Oak Ridge's Optimist Baseball boards and pursues his passion for health and fitness. Pedro Aguilera joined Russell Alexander Collaborative Family Lawyers in September of 2022 after working at a small practice in Toronto. He helps clients and their families navigate the legal processes, whether through virtual meetings, managing files, or reviewing court documents. Pedro earned a bachelor's degree in political science from York University in 2019 and later pursued a master's in human rights and multi-level governance at the University of Padova in Italy. Born in Havana, Cuba, and having lived most of his life in Canada, Pedro has a unique perspective of the importance of judicial independence and access to justice. He values Russell Alexander's innovative use of technology to make legal services more efficient and accessible, while giving him the flexibility to pursue his passion for helping others. So to start our conversation, we'll now start with Mark, who will speak to the overview of the divorce court system in Ontario.
Hello, everyone. Welcome to today's session. I am Mark Simpson. Today we're going to talk about the court process, the divorce court process in Ontario. In a general fashion, divorce can be very stressful and confusing. So our goal is to give clear and high-level overview so that you know what to expect and what your rights are. In terms of an overview, I think one, with respect to governing law, divorce may be governed by either federal legislation or provincial legislation. Both federal and provincial legislation are applicable to instances of decision-making, parenting time, child support, spousal support. Federal legislation deals with divorce. Provincial legislation deals with property rights and property claims. With respect to the court system itself, there are unified family court branches, which is a branch of the Superior Court of Justice. The specifics of the Ontario Court of Justice, Superior Court of Justice, and Superior Court of Justice Family Court Branch are set out in legislation in the Courts of Justice Act. There are schedules which indicate and enumerate which areas of law will be decided and determined and heard by which court. That also applies with respect to venue and forum as it relates to which court somebody should be applying to. Typically, that comes down if there's children involved, as far as going to the court for which the children reside in the applicable or corresponding municipality. So me having being servicing the London area, which is Middlesex County. If there are children involved in a court case, then the appropriate court to apply to would be the London Superior Court of Justice Family Court Branch. With respect to the division or the distinction between the Ontario Court of Justice and the Superior Court of Justice, or the Superior Court of Justice Family Court Branch, between the SCJ and the SCJ Family Court Branch, there is no distinction or difference with respect to the powers that a presiding justice has in either of those courts. The Superior Court of Justice is a function of the Constitution. The Ontario Court of Justice, on the other hand, is a function of the Courts of Justice Act, which is its enabling statute. And as such, the Ontario Court of Justice and the justices presiding in the OCJ, unlike the justices presiding in the SCJ, do not have inherent jurisdiction. You may know that as parens patriae jurisdiction. In terms of an overview and process for the materials, steps, filing application, disclosures, motions, trials, and other items, let's stay tuned. That's what we'll talk more about during the session. Also, in terms of an overview of a court proceeding, other aspects may be enforcement and appeals. If you have a family court case, or if you have a family case and looking for a resolve to address the issues, whether it's your rights, entitlements, or obligations, you may apply to court, although it's best to use the court as last resort. In applying to court, and going through the steps, that we'll share more information in a general sense with you during the next hour. At the outcome of the court, you will have relief from the court consisting of a final order. With the final order, you then have the right to enforce the terms for which you are granted as set out in the final order. In terms of any practical tips and takeaways, most cases settle without going to trial. Courts really rely on fairness and reasonableness. Most justices presiding over a family court matters, their function is to make sure that the matter is fair and reasonable for both sides, and both sides have had an opportunity to be heard. In instances involving one side with counsel and one side with self-representation, there may be some latitude that the justice has to ensure that there's fairness amongst both sides. In closing, with respect to this first initial segment of the session, thanks for joining us today, and we will turn it over to the next topic. Jen, back to you.
Thanks, Mark. And moving back to you, can you please speak to the grounds of divorce under Canadian law?
Grounds of divorce. First, we require a valid marriage, not one that is nullified as a result of any defects within the marriage. Next, we require a marriage if the marriage is outside of Canada, one that is going to be recognized as a valid marriage within Canada. If, for example, on a general sense, somebody is asking for a divorce in Ontario, but they were married outside of Ontario or outside of Canada, most often that's fine, subject to what the laws, restrictions, and um, prac certain practical effects to the foreign marriage. Once we have a valid marriage, we can proceed to get into the grounds as far as whether the spouse, one or the other spouses, wishes to dissolve the legal marriage. They may do so on three grounds. One, which is the most common, living separate and apart for the course of a year. To make this application may be made at any time. But after the application, of course, your affidavit for divorce must be consistent with the evidence. And if your evidence is that you're making the application on the grounds of separate and apart for a year, the affidavit needs to be done after a year of living separate and apart. Two other grounds that exist in the Divorce Act are adultery, usually requires a trial, not usually pled nor pursued because of the high potential for conflict within such a case. Or cruelty, same comments apply. There are certain bars to a divorce application, which commonly would apply in the event that a spouse were to apply for divorce on the grounds of cruelty or adultery. There are jurisdictional requirements such that at the time of making the application, the spouse needs to reside in the province. Of course, divorce is a federal matter. Spouse needs to reside in the province for which the spouse is applying to the court to ask the court to dissolve the marriage. And there's also some further statutory bars to making an application for divorce, which includes the provision for reasonable arrangements for child support having regard to the amounts as set out in the tables attached to the child support guidelines. In simple terms, child support needs to be in place in accordance with the tables per the child support guidelines. Otherwise, the presiding justice who receives your divorce material must and shall suspend or stay the application for divorce until the child support arrangements are in place. Divorce can affect eligibility on health benefits. Divorce can also affect other statuses and eligibility between the respective spouses. It would also speed up the clock from the standard 6 years to apply for property division to 2 years. Overall, I think those are the main points to point out with respect to grounds for divorce.
Great, thank you so much. Now, Lisa, could you please speak to the filing of applications, paperwork, forms, etc.?
Absolutely. So when you've decided that you're going to start a court application and you know what jurisdiction you're going to be starting it, and there are two different types of applications that you can start with. The first being just a simple divorce-only application. That's when you have no other issues that you need determined by the court, either because those issues just simply don't exist or because you've resolved them by way of a separation agreement previously. And then the other application is your general application where any issue outside of divorce is outstanding. Um, so all court matters are going to start with either one party or their counsel preparing and having issued the court application, which is going to set out their claims and facts of the matter along with any other necessary information. The initiating party is called the applicant and the responding party is the respondent. There are many other documents that are required to be filed with your general application depending on the circumstances and issues. So if parenting time or decision making is an issue, you're going to also be completing what's called an affidavit 35.1 form. And this talks about your decision-making responsibility, parenting time, or contact with the child. This form is going to include the applicant's information, the children's information, like their full names, date of birth, where they're currently living, details of any existing parenting orders or agreements. It's going to also include parenting plan and arrangements. So who currently has the day-to-day say, who currently has the main child arrangements and living arrangements, what the proposed decision-making and parenting plan is going to be, so where the child will live, the time sharing schedule, who will make major decisions, etc. It's also going to ask about any other proceedings involving the child. So if you had any previous court matters, those will be disclosed in this form. This form also gives you the opportunity to disclose any domestic violence, safety, and risk concerns. So if there has been any violence or abuse towards the child, the other parent, or others in the household, that needs to be detailed in this document. And as a reminder, affidavits are sworn documents. So whatever information you're putting in that form, you are swearing is true. So it could also include concerns with the other parent's ability to care for the child, whether they have substance abuse or mental health issues. And it's also going to disclose any current or past criminal charges, convictions relating to violence or child safety. The form will also include any parenting time or contact restrictions, and any information that needs to be known about the child's health too, if they have any medical conditions and if they're receiving support for those. And then another kind of subform off the 35.1 is the affidavit 35.1A. And that form only needs to be completed. It details if there's been any Children's Aid Society involvement. And it's a pretty short one. It's just going to say yes or no and the jurisdiction of where the Children's Aid Society is. So those are if you have child and decision making. If you also have support or property issues, you may also need to complete what's called a financial statement. And there are two different types of financial statements. So the first one is just, it's called a Form 13 financial statement. And that's the one you're going to complete if support is the only issue. So there are no property issues. So child support, spousal support, or both. It's going to include your personal information, your income information, so your self-employment, regular employment, any other income sources. It's going to have your expenses, so sort of a monthly budget, special and extraordinary expenses, and then a current list of your assets, debts, and liabilities. Supporting documents that need to be provided with those are your recent pay stubs, your notices of assessment and income tax returns, and proof of any other income sources. And again, these are sworn documents, so anything you were putting in this form, you're swearing that is true. So if you also have property issues, though, in addition or just standalone, you're going to complete what's called a 13.1 financial statement. And the key difference between the Form 13 financial statement and the 13.1 is the property section. So this section is going to have a lot more details about your assets and debts on the date of marriage, your assets and debts on the date of separation, and the current. It's also going to include any property that could be excluded. And then all of this information is used to calculate what each party's net family property is for the purposes of determining equalization. So those are generally the forms that will go with your application. And then after your application is ready, you submit it to the proper court for issuance.
All right, great. Thank you so much for that, Lisa. Now, Pedro, could you speak to serving and responding to divorce papers?
Yes. So now that you have your application ready and issued by the court, you need to send it to the other party. This is in legal terms what we call as service, what we know as service. Service is the court's way of guaranteeing that everyone gets a fair notice of the court proceedings. Under the family law rules, there are two categories. You got a special service and regular service. Special service is required when you're studying a case, like a Form A application or a motion to change. We also call these originating documents, right? So you cannot just email it. This is something that self-represented parties get wrong most of the time. You need to serve it in one of the ways listed under Rule 6 of the Family Law Rules. So you got personal service, which is handing it to a person directly. You can leave it with an adult living in the residence, or in some cases using mail, which is signed, or there is an acknowledgement. We call this Form 6, acknowledgement of service. Now, judges are strict about this. If service isn't proper, the court can refuse to move your matter forward. I have seen matters delayed because someone thought, I sent it by email, that's good enough. It's not. That's why at Rosa Alexander, we often use process servers to get the originating documents delivered properly. Now, once the documents are served, you have to prove it. This is what we call Form 6, affidavit of service. The person who served the documents swears an affidavit indicating when, where, and how it was served. So then both documents, let's say the application and the affidavit of service, gets filed with the court. Without an affidavit of service, your documents won't be accepted. This is really, really important because self-represented litigants don't get this right. They think that they can commission their own affidavit of service. And we see this often. So let's say that one more time. Without an affidavit of service, your documents won't be accepted, okay? So now, on the flip side, when you're being served, the clock starts ticking. So if you're served in Canada or the USA, you have 30 days to file your Form 10 answer. Or it can be a response to motion to change if you were served with a motion to change. So if you're served outside of Canada, we have many clients outside of Canada. Rosa Alexander is known for representing clients in Brazil, South Korea, you name it, United States, Italy, etc. If you're outside of Canada, you have 60 days to respond to this application that was filed in X jurisdiction in Ontario, let's say. That's why it's essential when you're served with an application to immediately contact a family lawyer. Once again, we have plenty here at RIO. Now, sometimes service is tricky. You may not find a person. In those cases, we can ask the court for something that we call substituted service. So we can do it via email or in some cases through FRO, through a family responsibility office. But the judge will want to see that you made a real, reasonable effort to serve them first. Okay, so you don't ask for substituted service if you at least didn't try once or twice. So at the end of the day, judges want fairness and efficiency. If someone is playing games, refusing service, delaying, or dragging things out, the court can step in and impose remedies, including cost. So the bottom line here is serve it right, prove it, and track the deadlines. It may sound technical, but it sets the tone for the entire case, for the whole case. Back to you, Geneva.
Just to give a shout out on that, if serving outside of the jurisdiction of Canada, the Hague Convention calls for the steps to take to serve. It's not simply a matter of sending the documents by courier or email to a process server in the jurisdiction that you wish to serve. You need to authenticate, translate documents. If we're serving documents in Mexico, for example, they need to be translated into Spanish, notarized, authenticated, and by virtue of the Hague Treaty, there is a central forwarding authority. Here it's Halsbury Court in Ontario, which is responsible for coordinating the materials from here in Ontario to the foreign jurisdiction. And the Hague Convention sets out certain requirements in terms with respect of the timelines and all of these further items and administrative matters that is to be looked after.
Great, thank you. Now we're going to speak to the interim orders and temporary leave. Pedro?
Yeah, so let's move to the second topic. So this is interim orders and temporary relief. So think of interim orders as a bridge. I always tell clients, think of them as a bridge. So to keep families stable while the more complicated issues are still being worked out. So that's what these interim orders are all about. So how do you get one? Usually by bringing a motion under Rule 14 of the family law rules. This is the Bible of family law clerks, the family law rules. We take care of procedure. Mark knows the legislation. We take care of the procedure here. So family law rules for us is key. Under Rule 14 of the family law rule, you can bring this motion. But here's the catch. Most of the times, you cannot bring that motion if you had not at least had one case conference. That's designed to encourage settlements or early settlements discussions. So, however, and there is a big however, there are times when the first case conference is not mandatory, such as when both sides agree and they have signed consents or minutes of settlement, and urgent motions we're waiting for a case conference will cause serious harm. So what kind of things you can ask for on an interim basis at a motion? We often see temporary parenting time, schedules and decision-making responsibility. In these cases, judges apply the best interest of the child test. Safety is always the primary factor, as you know. On interim motions, courts often preserve the status quo unless there is a strong reason to change it. So another type of interim order you could relate to is child support orders. Generally straightforward, based on the child support tables. And just heads up, because this is happening tomorrow, the tables will be updated as of October 2025. Another common motion for interim relief could be one related to spousal support. And finally, and this one we're seeing more often these days, are motions for exclusive possession of the matrimonial home. And then there is ex parte motions. So what does that mean, ex parte motion? That means that without notice to the other side. These are rare, or not that rare, but only for true emergencies. For example, imminent risk to a child, preventing relocation, or domestic violence. So when your lawyer approaches you and says, we have to draft an ex parte motion, you know right away, this is an urgent motion by de facto. So if the court grants an order through an ex parte motion, the order must be served right away, and the case come back really quickly so that the other side can respond. So that's the good thing about ex parte motion, is that there is no bureaucratic delays. From a family law clerk's perspective, what makes a strong interim motion is about being focused, factual affidavits. We put in police reports, pay stubs, childcare receipts, concrete evidence. Judges, they don't want fluff. They want clear proof so that the relief is necessary and proportionate. So the takeaway here is interim orders are about stability, not final outcomes. You get those final outcomes at trial or with a final order. So to get right emotion, you need the right evidence, file it properly, and the court will step in to protect families while the bigger issues get, they get played out. All right?
Great. Thank you so much. Now,
If I
Lisa.
can chime in on that, very, very clear. One thing that we all would like to also comment is that once you have an interim order, you should continue to take action. If you don't, and your matter stalls for a certain period of time, The court, I believe it's after a year or 2 years, could issue a notice of approaching dismissal.
Correct.
If, for example, you've obtained an interim order and you've moved and you haven't kept your address up to date with the court, and the court sends a notice of approaching dismissal to your old address and you miss it and your case dismissed, your interim order is no longer in force and effect. So once you have an interim order, it's encouraged to continue to keep the case moving forward because the court, under the Ontario Family Law rules, manages its cases under timelines. Normally, I think the notices are about a year or two of no activity.
All
Thank you.
right. Now, Lisa, could you please speak to the role of motions in court appearances?
Of course. So I'm going to start at the very beginning with the kind of like the very first court attendance that you might have to attend. So if your matter is on what the court calls the fast track, which is when there are only child support or parenting issues, not property, you're going to be assigned what's called a first appearance. And these are always held before a court clerk, not a judge. And your attendance is generally not required if you have retained counsel. And at this date, it's basically, I like to call it a court date to set another court date. You basically are just going to show up. The court clerk is going to make sure that all of the documents on both sides have been filed. And if they have, then you are granted leave to proceed with your case conference. If the necessary documents have not been served or filed, it's possible that the matter could be adjourned to another first attendance to ensure that all those requirements have been met. But if your matter is on the standard track, meaning that there are property issues, you are not going to be assigned a first appearance date. You get to go straight to the case conference, which can be arranged directly like through the trial coordinator or through counsel. So when you get to the case conference is the first conference that you will attend. This date is before a judge who will be assigned as your case management judge, which means that they are going to oversee all of your future conferences. The orders that can be made at a conference are very limited. Basically, orders for disclosure and orders that are made on consent are the only orders that you're going to get at a conference. But the judge can also give you leave for a motion, which I will get to in a minute. And it is common for more than one case conference to be held in a matter. During the conference, the judge is going to provide their opinion on the issues. And if there is an issue in your application that you consider urgent and you're not able to wait for whenever the first court date may be, because they could be several months out depending on what jurisdiction you're in, you can make a request for what's called an urgent case conference for a single issue to be canvassed prior to the regular case conference. And these are designated just for very specific urgent issues. So for example, if it's mid-August and school is coming up and we don't know where this child's going to be going to school yet or something like that could potentially be an issue. So then after the case conference, you then go to a settlement conference. And the main purpose of the settlement conference is to explore settlement of any remaining issues that the parties have not been able to resolve yet at this stage. Offers to settle are required to be served on at this stage and prior to the conference. During the conference, your case management judge will again provide their opinion on the remaining issues that the parties have been unable to settle. The parties are strongly encouraged to settle the issues by this point, because the next stage after the settlement conference is preparing for trial. And I don't think anyone wants to actually go to trial. So, because that is incredibly costly and time consuming. So, for this attendance, you're going to create what's called a settlement conference brief, which is going to contain all of your issues and a copy of your offer to settle. And then if for any reason that your matter does not settle, it would be set down for a trial management conference. And I believe that is going to be discussed on later in the session. And now for your motions. As has been talked previously, like the judge at a case conference, they can give you leave for a motion. And then there's also what we call paper motions. So the regular motions are typically going to be brought after the initial case conference and that the issue has been canvassed by your case management judge. Your case management judge is not going to be the same judge that hears the motion. It's going to be a completely different judge that has not reviewed like any of your originating documents or anything like that. If there is an urgent issue that cannot wait for the scheduling of a regular motion, you can request an urgent motion date. The judge can make temporary orders at the motion. And then for your paper motions, which are 14B motions, those are for your procedural, uncomplicated, or unopposed matters that are just heard in writing and there's no court attendance necessary. These are generally used for consent orders or disclosure orders, and they're very procedural.
Great, thank you so much. Now, Pedro,
Anything on the mode of proceedings?
pardon?
Anything on the mode of proceedings?
We're just going to go ahead and speak to the disclosure and discovery processes. Pedro?
For the court appearances, for the conferences, and for the motions and whatnot.
Usually we found those in the notice of profession. Depending on the jurisdiction, we see that there is a table that will let us know what the mode of proceeding is. If it's virtual or not, that varies on jurisdiction. So in Newmarket, they may have a mode of proceeding depending on. Is that what you're referring to?
Yes.
Okay.
This is the consolidated provincial practice directions. I think the mode of proceedings is in the consolidated practice directions, correct?
Correct.
Okay, now, Pedro, could you please speak to disclosure and discovery processes?
Yes, most definitely. So, yeah, finally, let's talk about the disclosure and discovery, because without disclosure, nothing moves. At least for us clerks, we know that disclosure is the oxygen of family law. It's what allows lawyers, clerks, and judges to understand the real financial picture. And you get your intro letter from the lawyer, and almost always right after, at least in my experience practicing family law, one of the first things we jumped in is, okay, show me the money, which is, okay, you have to release this financial disclosure. So, and let's be clear here. This is something I say to all my clients. You have to be transparent. And I stress over the fact that you have to be transparent from the very beginning. It's a must. It starts with the financial statement. Lisa already touched on this. It's either Form 13. This is just when there are child or spousal support claims. And then there is the Form 13.1, where there is, if you have property or equalization claims are involved. Now, along with these forms, you're expected to provide tax returns, notice of assessment, pay stub, bank statements, you name it, GICs, business records, and more, much more. That depends, that varies case by case. Now, as a law clerk, I always keep disclosure organized in a disclosure brief, index and hyperlink. So that makes the life of not only the client, opposing counsel, but most definitely the judge that is going to review this document, it makes their life easier. That way, when a judge asks, when the date of separation, bank balance for show and so, I can show it instantly, right? So then there is Rule 20, which covers questioning and the request for information. When you're served with we call it RFI, a request for information form 20. So to proceed with questioning, you need leave from the court, right? And you must also show that questioning is necessary. Now, judges take disclosure, once again, very seriously. If someone fails to disclose, the court can impose remedies, ordering disclosure by a set date, awarding costs, striking documents, and even excluding evidence at trial. In the most common the most common disclosure problems that I see are missing date of separation balances. For example, providing a January 1st bank statement when the date of separation was, I don't know, January 24. So that 23-day gap matters, and it matters a lot. And sometimes clients, they get upset because you ask them from the very beginning, hey, the date of separation is, I don't know, January 1st, September 1st, December 1st, but they provide a different date. And it can get frustrating. That's why I say to every single one of our clients from the very beginning, get organized, because these things, they matter and they delay the process. So another problem that we see is incomplete investment records or bank statements, or if we're talking about Section 7 expenses, no receipts or proof of payment. This this is just the tip of the iceberg, because if you really want to talk about disclosure, we can truly spend an entire day just talking about disclosure. I'm really excited about disclosure because I work with disclosure often. So this is what I do. This is what I do. So the bottom line is disclosure, and this is, I will summarize like this. Disclosure is about credibility. Provide it fully, keep it organized, update it regularly, and if you do that, you can move your case forward efficiently and you can avoid unnecessary costs and delays.
Great, thank you. Mark, could you speak to the settlement discussion and trial preparation process?
Of course I can. In terms of the settlement discussions during a court process, they should not be in the earshot of a presiding justice. And the settlement discussions that do occur should not be brought to a justice's attention, save and except for presiding settlement conference judges. The family law rules encourage litigants to engage in settlement discussions for purposes of narrowing and/or identifying the issues that are in dispute and possibly making progress in resolution of those issues. Settlement discussions should generally be verbal after there has been an exchange of written communication. And as Pedro hasn't shared, disclosure. Without the disclosure, it's nearly impractical to engage in fulsome settlement discussions because you're not sure what hand the other party is holding. That's not how we do family law. Family law should be open and transparent, and the courts are there to ensure that's how things play out. Settlement discussions are immensely valuable, but they occur after the disclosure process, and of course, before one or the other parties asks the court to weigh in with the determination on any legal issues. A common way of looking at the benefit of settlement discussions is to narrow issues so that we do a lot of the heavy lifting for the court or the judge. So that if we start with 10 issues, we resolve 6 or 7, we paper that into a partial understanding, could be called an agreement to agree. We go to the court for the determination on the remaining issues, and most often, but not always, judges will take the terms that are agreed upon in part or in whole to incorporate it into a final judgment. And most judges are going to ensure that they try to respect the parties' autonomy in order to arrive at their own outcome. And that's more often than not welcomed. With respect to the trial process, if settlement discussions haven't resolved in final resolution of the court matter, and we've gone through all the steps that Lisa has shared, case conference, motion, settlement conference, trial management conference, and the case is still unresolved and open, the next step would be trial. The evidence tendered at trial is generally viva voce, although supporting and third-party witnesses can provide their evidence by way of affidavit material. For purposes of distinguishing between what you can say in an affidavit as per a motion and what you can say in a witness box, it's one and the same. What you say in a witness box is what you can say in an affidavit. It's tendering evidence to the court, so the court has that on record to be in a position to make final determination and final orders with respect to the outstanding issues that are in dispute. Trial is essentially marshaling, tendering, or submitting your evidence of your side, testing the other side's evidence, and the judge is overseeing the nuances of each party's case, paying very particularly close attention to any areas that are not contested or challenged. If you're in a family law trial and the other side raises outlandish, what you may say is silly issues, it's very important to counter and cross on those silly issues. If you don't, that means that their evidence has gone in uncontested and uncontroverted, leaving the justice in a very, very difficult position if that's the only evidence on certain points. Trials can last, nature of trials can go from uncontested trials to full-blown parenting trials, which can take a week or two. Normally, if just relating it to parenting issues, if you're going to trial to pursue joint decision-making and shared parenting, normally don't want to get into all sorts of nasty allegations about the other side because joint parenting requires communication and cooperation. If you're going to trial with respect to support issues, as Pedro has indicated, it's essential to have all the disclosures. If you're going into trial, and as Lisa has shared from motions, there's orders that have been made on motions. Those may very well set status quo for the judge to work from. All of these considerations can definitely be further explained from arranging a consultation with any of our fine counsel at our firm, Russell Alexander.
Great. Now, Lisa, could you speak to the final hearings and divorce orders?
Absolutely. So the final hearing, if you're in court, is either going to be trial or what we call a summary judgment motion. And for trial, which you don't want to get there. But what you're going to have when you're, just to touch add on to what Mark was saying, when you're preparing for your trial, you're at the end, you're going to have what's called a trial scheduling endorsement form. And that's basically going to be your roadmap of when all of these documents are due, what the outstanding issues are, expected witnesses, any other procedural issues. And that is all the information that's going to be used at trial. So that is one final hearing, and this trial sittings are only held twice a year and they run for about 2 to 3 weeks for each run. And you don't know when you're going to get called for trial. So all you're going to know is that you've been placed on these sittings that run for 2 to 3 weeks, and you could receive less than 24 hours notice that you're going to have to show up in court to start your trial. So it's really imperative that your trial preparation is complete by that stage. And if your trial starts during one period and does not finish, it'll be like move to complete at the next sittings, which are generally months and months away. So until then, you're just kind of sitting in a holding position until you can get reached again. Summary judgment motions it is like a very long motion. And that is when there are no triable issues. So the issues are straightforward, the facts are the facts, and it kind of like is what it is. Whereas the trial, obviously, there are issues that a judge needs to determine. So the good news, though, is that if you have consented to a final order, you don't need to worry about the final hearing, because what you or your lawyer is going to do is you're going to use that handy 14B motion form, which is the paper motion, and you're going to submit your consent to be turned into a final order that way. And then sometimes if you're consenting to a final order, and you don't want it actually turned into an order, maybe you just do separation agreement or minutes of settlement, what we can do is ask for the court to sever the divorce claim from the other issues, which will allow the divorce to proceed as a standalone issue so you can get your divorce order. And just to touch on what Mark said earlier, the court will not issue your divorce order if proper arrangements for the child, like child support arrangements, have not been finalized. So if you don't have that information, because that's the type of information that has to go in your affidavit form 36, which is the final document that you're going to file with your divorce, and you have to set out in that document what the child support arrangements, et cetera, are. So the judge has that information when they're deciding if they're going to grant you your divorce. So yeah, so those basically at the final hearing is either summary judgment motion, trial, or a consent, which is filed by motion to get your final order.
Great. And then to finish this off, Mark, can you please speak to the post-divorce process?
Of course. On the trials, probably usually spending 3 times the prep time for the amount of time in court. So if you're looking for examinations of an hour, you're probably spending about 3 or 4 hours of prep time outside of court. It's usually a 3-to-1 ratio, I find. In terms of the post-divorce process, once you have a divorce order, we can use an example. The divorce order includes parenting, decision-making, parenting time, travel, important documents, child support, Section 7, spousal support, property division, equalization, health insurance, life insurance, et cetera, et cetera. All of these things, as you've heard, have collateral effect. If you have a divorce order and your spouse was on your health benefits, it's best practices to check in with your health administrator to see whether or not there's any impact as a result of the divorce with respect to maintaining the spouse on the health benefits. Wouldn't want to have the health insurance carrier approach you indicating that the spouse should have been removed a year or two ago and looking to address the expenses that have been submitted through the insurance. Also, life insurance. If you're the recipient of a divorce order, which by the way, you're the recipient of support payments under a divorce order, you may wish to secure that with life insurance. If by doing so, you may want to follow up to make sure that you receive proof of beneficiary designations and whatnot. In terms of the parenting issues, you may wish to share a copy of the divorce order with a children's school. You may need the copy of the divorce order for purposes of applying for children's passports. Once you have a divorce order, one of the post steps is to obtain a certificate of divorce. The certificate of divorce is what you need in order to marry in the future. So within 31 days after the divorce order being made, it has legal effect. At that point, not on the date of the divorce order itself, but 31 days after the date of the divorce order, you can then say that you have a legally effective order, which dissolves the marriage, sets all the relief. You may wish to circle back to the court to ask for a certificate of divorce with respective enforcement. Say, for example, you have been received or successful to receive a divorce order from which you're entitled to receive support, but the other party is not paying support. You can choose to enforce the support order, which is the divorce order, by way of state enforcement through the Family Responsibility Office. Every order that involves child support or spousal support or Section 7 expenses that is issued in the province always by default starts with an issued support deduction order and support deduction order information form, which is the jurisdiction for the Family Responsibility Office to enforce the divorce order, which sets out the support provisions. So on the issuing of a divorce order, which includes support terms, there's also an issuing of support deduction order form, which gives the jurisdiction to the Family Responsibility Office to enforce the support provisions of the divorce order. If you do not wish to go through the Family Responsibility Office, that's fine. You do not have to. You can do something called the notice of withdrawal. If you do a notice of withdrawal and the payor does not make the payment, support payments as called for in the divorce order, the family law rules set out the process and procedure to follow in order to enforce the support terms, which could include writs, garnishments, liens, etc. With respect to appeals, on the making a divorce order, the appeal route would be to, depending on the nature of the relief, as that is first, if you have a divorce order, you're dissatisfied with the divorce order, first thing to do is review the Courts of Justice Act. It'll outline the appeal route. Once you know the appeal route, to go to the divisional court or the Court of Appeal, depending on what is contained in the divorce order. There's very, very important timelines in place to provide a notice of appeal and to take certain steps in order to bring forward a request to appeal the order. Payment money orders that are under appeal are necessarily stayed once you deliver a notice of appeal. Parenting orders are not stayed. They are operative until you have successfully appealed. Appeals are incredibly high in terms of very high threshold or very difficult to successfully appeal. A lot of discretion is extended to the trial judge that makes the divorce order, and that's for the purpose of bringing some finality to the case. So in terms of enforcement and appeals post-divorce, I think share the divorce order with those applicable parties, third parties who should be aware of the terms of the divorce order. Be aware and familiar with your enforcement rights, something that we at Russell Alexander are more than happy to further discuss with you. And also be very cognizant of the date on which the order was made, not the date that you received the order from the court. With respect to appeals, if you receive an order that you completely think the court completely got it wrong, it's very important to pay very close attention to the date of the order, not the date on which you received it.
Can't hear you, Jen.
Thank you so much for sharing, everybody. So that concludes today's program. So thank you for tuning in to Family Law Now After Hours. After this session, a brief survey will appear, allowing you to share your comments and suggestions for future topics you'd like to explore. Your feedback is greatly appreciated. So please book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers. You can contact our intake team at intake@russellalexander.com and mention our after hours series to schedule your appointment. Registration is now open for our next event, which is spousal support, who pays, how much, and how long. So please go to russellalexander.com/family law now to register. And thank you again to our panelists for sharing their insights today. And thank you to our viewers for tuning into Family Law Now After Hours. So thank you and good night.
And thank you to our host.
Thank you.